As much. Very good. Okay, the next case on the docket is, well, that's a difficult one to pronounce. I'll let the lawyers do that. Case number 142890.
I'd like to reserve 5 minutes for rebuttal.
Okay.
May it please the court, my name is Phil Daniello, and I represent appellants Harold Dean and his 2 daughters, who obtained a money judgment against Ganesh BANSRUPAN in excess of $207,000, which to date has not been satisfied. The action below was a supplementary proceeding against BANSRUPAN's relatives, including Renuka Wood, his longtime girlfriend and mother of his child, and the McKenzies, who are his sister and her husband, based on the alleged fraudulent transfers of real property. Although the trial concerned 3 properties that were transferred, due to the limited time I have here today, I will focus on the most valuable piece of property, which is the commercial property on Winter Garden Road that was transferred to the McKenzies. This is the property that BANSRUPAN rented to the appellants after defrauding them in the sale of his grocery business, a fraud for which ultimately the appellants obtained the underlying money judgment. This property was transferred on January 29th, 2008, just 5 days after the Deans filed a motion to bring a counterclaim for fraud against BANSRUPAN, and only 2...
Let me get to that. I think what looks like the heart to me of the case is that the trial judge made 2 findings that would mean that you lose if they're adequate. The good faith finding and the reasonably equivalent value finding. In your brief, you say things like there's no credible evidence to support. When I hear wiggle words like that, we don't determine credibility. That's a trial judge's determination. So it's looking to me like there is evidence in the record to support both the finding of good faith and the reasonably equivalent value. So why don't you address those 2 points and why you think that there was no evidence to support, competent substantial evidence to support those 2 findings?
Certainly. We don't believe that there was evidence to support those, and we've stated that the trial judge made clear errors of fact with regard to the valuation and clear error of law with regard to the good faith issue. Relevant to the valuation, this Winter Garden property is where the Deans leased the grocery. The trial court mistakenly concluded that they had purchased the property. The appellants presented unrebutted evidence that the property's value was worth at least $500,000 in the form of an expert appraisal. At no time did the appellees present a rebuttal expert or any rebuttal evidence. The entire basis of the appellee's belief as to the...
Weren't those expert opinions substantially, there were credibility problems with them that came out on cross-examination, correct?
I don't believe so.
They weren't considered, they were, I mean, it was a distressed property, there were no tenants in it at the time, you needed to sell it quickly, all sorts of other things that...
Well, Best agreed with the fact that he didn't know that of the 3 units, 2, which were your clients, were empty, and the 3rd was going to be empty soon, correct?
That is
correct. Take that into account.
He didn't take that into account because the history of the property is that it was always fully leased, and we brought out in evidence the fact that his valuation was based on 1, comparable sales, and 2, comparable rental income. Prior to the transfer, the Deans were paying $19.50 a square foot in the rental income. His valuation...
Took out or damaged some of the fixtures in the store, wasn't it?
Whether or not that happened is debatable, but regardless of whether...
Their testimony...
fact for the judge to find?
the damage to the store is not a fact going towards the valuation. The valuation is comparable properties and comparable rents. The comparable rent market value that the appraiser found was $14.50 a square. The Deans were paying $19.50, and BANSRUPAN testified that shortly after the transfer, it was fully leased, and they were paying and receiving $14.75 a square. So it was a very short window where the property wasn't fully operational, and that was because of the sewage problem. As soon as that was corrected, the property was fully leased. The comparable sales and the comparable rents in the market supported that. In addition, this court has said that where an unrebutted testimony of an expert appraiser must be accepted unless his errors and omissions are so glaring as to render his opinion illogical. One of the several cases we cited, which is the Beach Community Bank case, in that case, the court noted that a trial court would abuse his discretion, rejecting an appraiser's testimony where his qualifications, methodology, and data were never challenged except through non-experts' attempted impeachment. And that's what they did here. This is no different. They tried to impeach the appraiser's valuation but offered nothing which would affect his opinion. In addition,
this was an individual, though, Mr. BANSRUPAN was an individual who wanted, regardless of any, take your client and their claim out of it, he wanted money quickly for health reasons, and he also wanted to get rid of his assets so that he would qualify for Medicaid.
yes.
That's part of that's 2 out of 3 reasons that you would say he was doing this, right?
Yes, and he's not
He
allowed.
wanted it done quickly, and again, didn't the appraiser, Mr. Best, agree that on a commercial property like this, it would take perhaps up to a year to sell it at the price he thought versus understandably taking a lower price for a quicker cash sale?
But the Fraudulent Transfer Act doesn't allow you to take that into consideration. The Fraudulent Transfer Act looks at the value of the property.
Those things affect reasonably equivalent value, correct? So in that, I mean, more of a distressed sale is going to be a lower price than what you could get if you're willing to leave something on the market for a year. Your appraiser, Mr. Best, testified to or agreed to, correct?
With respect, that's correct. The distressed sale does get less money, but that's not what the analysis is. The analysis is market value. And where you transfer property to an insider, you must do it for reasonably equivalent value. That's what the entire fraudulent transfer statutes are about, is to avoid exactly what happened here, where you are in financial distress, you have creditors, you have these reasons that you need to get rid of your assets, and you just give them to your relatives. And in giving them to the relatives, he was able to maintain complete control over these properties. And exercise his discretion over these properties the same way that he did prior to the transfers. So it was a sham transfer. And that's why we have the fraudulent transfer statute. The fraudulent transfer statute doesn't say reasonably equivalent value as distressed or as it would take to sell. It says reasonably equivalent value. The case law for defining that says that that is market value. What was given versus what was given away. And the law is that when you give property to an insider, it's automatically void under the fraudulent transfer statutes. If the effect is to hinder and delay a creditor, and you've transferred it to an insider, it's void.
Not if it's in good faith for reasonably equivalent value, correct? That's the defense.
Actually, if you look at the case law, and this case law goes back to 1851, the issue when you transfer to an insider for less than reasonably equivalent value, you don't get to the question of good faith. You don't get to the question.
So what's your best case to say that reasonably equivalent value doesn't, it's an abuse of discretion for a trial judge to consider a distress sale kind of price for a property when determining reasonably equivalent value?
I do believe it is an abuse of discretion to determine the distress sale price.
I know you believe that because you argue that, but is there a case that says that? Is there a case that says you can reasonably equivalent value only means the full value that you could get if there was no distress and no other independent reasons to sell quickly and, all the factors that we have here?
Nothing that says that directly, but the case law does say that you look at the market value.
Right, but market value, Mr. Best agreed that market value includes a view at these other factors.
I believe what Mr. Best said is that there are circumstances where you can sell to family members and you can sell distressed that would be less than reasonably equivalent value. That does not change the market value. The market value is $500,000. The tax appraiser valued it at $500,000, and BANSRUPAN's own testimony said it was worth $600,000. What they did is they gave away substantial value in this property to protect himself in case he passed away. And what are you doing if you're protecting yourself? You're protecting yourself from creditors. You're protecting your estate from creditors. This case...
Didn't he use the money he got to pay off at least some creditors? Again, maybe not your clients, but wasn't the record that when he got paid money, he paid off a mortgage? When he got paid other money, he paid off a different mortgage or more of the same mortgage?
The only evidence that was presented before the court of creditors being paid were the secured creditors. He was able to pay off the secured creditor for the Winter Garden property, but it still had about $300,000 in equity.
You don't want to talk about the condominium, but let's do just very briefly. Mr. BANSRUPAN reserved a life estate unto himself when he sold, whether he sold it or gave it as security, and I know there's at least dispute. The trial judge found that it was a sale. Your appraiser did not take into account the life estate when he was valuing the property of that condo, did he?
The appraiser is not supposed to take into the consideration...
Did he?
No.
Okay.
Not,
when you think of somebody buying a condominium, all it's useful for is as a resident, there is somebody in there. You can't move them out because they have a life estate. What's the value of that? When are you going to be able to sell it? That seems to me to be a very important thing to consider.
the consideration that the appraiser does is a snapshot on the day of the transfer, not what happens after the transfer. And if you
On the day of the transfer, when the transfer occurred, which is what you're concerned about, you're not concerned about before, you're concerned about what happened with the transfer, he kept a life estate. To me, the market value of that is very hard to figure. I'm not an expert in real estate appraisal, but if you don't even consider it, how are you going to get the right answer?
Well, 2 points. First, the whole life estate thing was a sham, and they testified to that. They testified that it was never intended to be a life estate, that if he died, the Mackenzies would simply give the property back to his daughter. So the life estate is a sham in and of itself, and the appraiser's job is to take that snapshot immediately before the transfer, not after the transfer. That tells us what it was worth if the transfer hadn't occurred. That's what is relevant as far as the market value. Once they do the transfer, whatever happens to the property thereafter will change and affect the value of that property, as will the passage of time. But the snapshot is, here's what it was worth immediately before the transfer. And they essentially gave it away for nothing. The argument is that they sold it for $50,000. They didn't. If you look at the facts of this matter is that the promissory note still exists. The $50,000 hasn't been forgiven. They allege that they did a loan for $50,000 that they later backed up with a promissory note, but that promissory note hasn't been released, hasn't been forgiven, and they're going to give the property back to his daughter at some point in time in the future, whether he passed away because of his illness or whether he passed in the future. So the whole thing was a sham, and it's proper to determine its value on the date of that transfer. Regarding whether or not the Mackenzies are bona fide purchasers. This court and every other court has ruled that bona fide purchaser is basically an arm's length transaction for reasonably equivalent value without knowledge of any defects that would taint the transaction. The Mackenzies fail all three of the tests. It's not an arm's length transaction. They're insiders. The third DCA in the Mansolo case stated that if you transfer property to an insider, by definition, they're not bona fide purchasers. They didn't accept for reasonably equivalent value, and they had complete knowledge of BANSRUPAN's financial difficulties. They had complete knowledge of his medical bills that he couldn't pay, his need to divest his assets to qualify for Medicaid, and they actually had knowledge, even though it's not relevant that they did, they had knowledge of the dean's claims. They knew that he had a dispute, and they can't simply willfully go on and ignore these things. They have to make inquiry, as the law states, to be a bona fide purchaser.
Was there that they had knowledge of the dean's claims? My reading of the record was January 4th, 2008, the friend prepared a deed, a bill of sale, and then January 29, the quitclaim deed, Ms. Bruveris, I'm not sure how you pronounce her name, prepared the quitclaim deed that was signed ultimately by Mr. BANSRUPAN, and then the counterclaim's not filed till February, is that correct?
The dates aren't exactly correct there, Your Honor. First of all, I don't want to be drugged down the rabbit hole of whether or not they had knowledge of their claim, because that's irrelevant. The issue is whether or not they had knowledge of any claims. And the statutes say that your claim can arise before or after. If it rises after, they couldn't have knowledge. And as far as the dates are concerned, the initial request for an accounting was done on December 10th, 2007. The motion for the fraud counterclaim was January 24th, and 5 days later they did the transfer. And
or
all
20 days earlier, if you believe the bill of sale was intended as the transfer.
even if they did it 20 days earlier, it's after they made the accounting claim in December.
But
And
what evidence is there that the McKenzies knew about the accounting request?
the McKenzies, the Woods, and BANSRUPAN all testified that they knew that there was a dispute
I
with,
understand that. They knew there was a dispute, that your clients moved out of the store because they thought not that they thought, there was a problem with the sewage. They moved out, they knew there was a dispute, they weren't paying their rent. They knew about that kind of generally. I mean, I don't think there's a dispute about that, but in terms of more than that, knowing that they were going to make a claim for a couple $100,000, there's not that kind of evidence, is there?
there's not more evidence, but there doesn't need to be. They don't need to have knowledge, and they had enough knowledge to put them on inquiry. And I see my time is up, and I'd like to reserve the rest for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Derek Angel. I represent the impleader defendants, appellees, the McKenzies, who are over my right shoulder, as well as Ms. Wood. And, Your Honor, Judge Lawson, I think you hit the nail on the head. This case really was a trial on two questions of fact, which was as to all three of these transfers, which I question whether even Ms. Wood's house was a transfer, but in any event, it was whether the appellees took these properties in good faith and for reasonably equivalent value. And those questions are inherently factual. I cannot think of questions which are more factual. Good faith is defined, we look at it objectively, right, as the cases tell us, but that is something for a jury, or in this case, a trial judge, to determine, as is reasonably equivalent value. And we look at the cases that are cited by the appellants as to the expert appraisals, and every one of those cases deals with a situation where a trial judge has to fix a certain price to a piece of property. Usually it's a deficiency judgment where they are fixing something to the penny. In this case, Judge Kest was looking at whether the value given, which is $250,000, and I hear sham transfer, that's $250,000 that our clients have taken on a personal line of credit, and this is essentially the retirement plan in this building, but whether that amount was reasonably equivalent to whatever Judge Kest believed the actual value to be. That is a gray, amorphous, factual question, which is why we have fact finders, and of course Judge Kest found that it was. And as looking at the Harbor Heights property, Judge Edwards, you're exactly right. This was, how do you value a remainder interest in a life estate? And that's got to be one of the most difficult sort of analyses that an appraiser could do. You're looking at how much longer the life estate will last. The remainder, speculation would run amok in that sort of analysis, and you have 10 different opinions from 10 different appraisers. And as far as Ms. Wood's property, I think when I was looking through their cases again, the Demosthenes case, I hope I pronounced that right, explains that that was in an opposite situation where here we have a situation where I think Mr. BANSRUPAN, and I wish I had sort of recognized this when I wrote the brief, he had nothing more but naked legal title in the property when he took it in the first place. That it was as I put in my brief, a sort of do-it-yourself estate planning measure. These were informal, familiar relationships, no sense, no objective, reasonable sense that anyone would know that there was this potential for a default $250,000 practical judgment against Mr. BANSRUPAN coming down the pipe. We have a gentleman who suffered 5 surgeries, who, as Mr. Osman, I can't understate the importance of his testimony, the lawyer who, of course, they waived the privilege and discussed what his communications were with Mr. BANSRUPAN, that in May of 2008, this is almost half a year after this respectfully contrived counterclaim was filed, Mr. Osman testified that they didn't even talk about the counterclaim and a proffer, and therefore not technically in the record, but Mr. Osman said it because he found it to be meritless. This is common in real estate disputes, in lease disputes. And so Mr. BANSRUPAN, as far as we know, wasn't even aware of a counterclaim. The only evidence they cite to that he was his testimony that, and remember, he's going through all of these surgeries right in this time frame. He says, I was going to pursue this when I got better. Pursue, that's usually a term you use when you're the one being pursued. So I'm not convinced by any stretch that Mr. BANSRUPAN had any idea or even objective reason to know that he was subject to a counterclaim. Let's not forget that Mr. BANSRUPAN he was still owed $40,000 from Mr. Dean, that Mr. Dean had stopped paying on his rent. Now Mr. BANSRUPAN has the Kirkland property, now he's not getting his rent, financial distress, and he's looking to how can I best take care of my obligations. And he approached his sister and her husband, and they, over a 6-week period, investigated the value of the property. As Judge Kess said, legitimate negotiations back and forth, and it came up at the value. And I know in their brief they take issue with the fact that Mr. McKenzie could not remember the specific name of a realtor or what have you, but he remembered the process. And for years later, I mean, I don't know how I'd remember the name of a realtor several years later. I mean, Judge Kess found that our clients were credible, they testified truthfully, he had reservations about Mr. Dean. As the court has noted, these, obviously I know who I'm speaking with, the role of a fact finder, that we do not disturb those on appeal. And I hear, again, in Mr. Dianello's argument, I heard some of the sort of arguments that are in the brief, that re-litigation of factual issues. As far as Mr. BANSRUPAN kept control of the properties, that these are the insiders, Judge Kest was well aware of that, obviously weighed that in reaching his conclusions. And as far as the allegation that the life estate transaction itself was a sham, and I think that it's fair to say that the McKenzies weren't exactly sure what they were doing. This is, again, familial, but certainly for value, the value of a life estate. They finally went to a lawyer, Mr. Ozma, who is familiar with people towards the end of their lives, as everybody believed Mr. BANSRUPAN to be, including Mr. Ozma, and said this is a sort of effective, cheap, it's a convenient way to do this. I do the life estate, the remainder is a smart way to protect everybody's interest, to accomplish your goals. That's the instrument that he came up with. Whether or not the McKenzies 100% understood that, I think everybody achieved the goal of what they intended to do. And the same thing goes for Ms. Wood. Certainly on the very front end of getting a case like this, if you take their case without having heard our client's story, it certainly looks a little odd to just quick claim somebody off of a deed. But here we have the history where it wasn't, Ms. Wood was having her mortgage paid by Mr. BANSRUPAN. It wasn't just for her time working at the grocery store. This was alimony, this is child support. And of course, alimony would never be compelled.
Did he live, he didn't live in the house, did he? He lived in the condo, right?
That's exactly right, Judge Edwards. He lived and maintained a residence at the Harbor Heights properties from the late 90s, as far as I know, to this day. And the entirety of the time, Ms. Wood, who brought all the original equity into the house, and she worked at the store, but she was also raising the child at that house. And so that's his, again, informal sort of situation. No one has any nefarious intentions throughout this whole case. I think Judge Kest's opinion makes that clear, that his findings make it clear. Understanding it's an objective measure, Judge Kest went further and found subjectively that there were no nefarious intents here.
The appellant keeps trying to say that good faith is not a defense, is not a factor to consider. Why should we believe you instead of him?
Well, I also heard appellant's counsel mention the good faith as a matter of law should not be found here. I just don't understand that. It's like saying reasonableness is a matter of law. This is a factual question. And every case they cited going back to the 30s and the 19th century, and I think if you look through the bankruptcy code and the history of fraudulent transfers that go, I remember in bankruptcy class in law school about a barren cow was a major case from the 1800s. It's all about, from the transferee's perspective, it's all, those two questions continually come up, good faith and reasonably equivalent values. You can imagine all sorts of situations where you have one but not the other, and again, in those cases that they've cited on valuation, here we are reasonably equivalent, not fixing a direct number on it as to good faith. That's for the fact finder, and the fact finder found good faith on the part of all of our clients, if not as well as Mr. BANSRUPAN, without expressly stating it. The court didn't even say that Mr. BANSRUPAN committed sort of a fraud, and I, in fact, would think that he found the other way in light of finding Mr. Osma credible and Mr. Osma saying, we didn't even talk about this counterclaim the day that I wrote all the deeds. So I think that as a factual finding, competent evidence clearly supports the findings of the trial order. And then finally, I would just mention that I heard that as a transfer to an insider is per se fraudulent. That's certainly not the law. All of their cases, as one of the elements, it always includes a good faith, reasonable value is always a defense. I think that's universal. There are some of the statutes which deal with insider trades a little bit differently, but I think I've discussed all the statutes in depth in this case. This was a case based on an affirmative defense of two questions of fact that were all decided in our favor, and unless the court has any additional questions.
Okay, thank you very much.
Thank you very much.
I'll start my reply by saying that if this is not a case where fraudulent transfers exist, then it's hard to believe any other cases where a judgment could be obtained for a fraudulent transfer. The issues raised as far as the good faith and the reasonably equivalent value is very clear in the law, and it has been that way for some time. The nefarious intent of the transferees is not relevant. The intent of the transferees is completely irrelevant to this case. The law is that where transfers occur to insiders that have the effect of hindering or delaying a creditor, it is per se a fraudulent transfer. And as far as they're not being...
You're saying as a matter of law there is no defense of good faith for reasonably equivalent value?
There is no defense for reasonably equivalent value as far as the issue of a transfer to an insider that has the effect of hindering or delaying a creditor. That is the law, and it's been the law since the Gibson v. Love case in 1851, which has been repeated many times by the Supreme Court, the McCown v. Allen case in 1896, and then numerous other cases we cited in our brief. Good faith is a general defense that's allowed for, basically, and if you look at their cases on good faith, it goes to non-insiders. An insider has an extra burden that they have to go through, where the intent of the transferor, which has been BANSRUPAN, is to hinder or delay his creditors, and I think that's clear from his testimony. He said that he had to protect himself if he died. He had to protect himself from his creditors. He had these financial difficulties. His intent is clear. The transferee's intent is irrelevant, and there's no case law, and there's nothing within the statutes which show that the transferee's intent is relevant. The only defense that they have as far as good faith is that they paid reasonably equivalent value, and they're not insiders. They can't be bona fide purchasers being an insider that didn't pay the full value for the property.
Here, the fact that the McKenzies drove around, read the newspaper, looked on the internet, and talked to some realtors to try to get some idea of what the old Winter Garden Road property was worth,
Well,
doesn't that show that it's not some kind of scam between brother and sister? And isn't that some evidence to show it's a legitimate purchase and sale?
Not really, and the reason is that this very same type of testimony was considered in the Weinstein versus Park Manor case. And in that case, the court said you have to reject an owner's statements as to his opinion of value where he cannot show specific facts that were considered. And on his testimony, all that he could say is that they drove around and they looked at some other properties. He couldn't say where, he couldn't say what properties or what realtor, he couldn't say what records that they looked at, and it was directly contrary to his testimony that he had previously made that they didn't do anything, and his testimony was the reason that he remembers better now was because he's suffering from an undiagnosed condition, medical condition, that allows him to remember better now than previously. I think that's my time if you have any more questions.
Thank you very much.
Thank you.
Thank you both.